Hello, everyone. I'm very excited. Um, it's transcript time. I'm not the first. I certainly will not be the last to cover this. Mm. I hope you don't mind while I'm drinking my weak coffee. Anyway, my excitement is twofold. Number one, just because it's anything Lorne, I am interested, and this is sort of this is fabulous. This sort of stuff, you know, I would say it's a once in a lifetime occurrence, but we all know that's not true. This is the second time. I'm sure there'll be a third. Anyway, my other excitement about this is I'm the sort of nerd who will on occasion go to the federal courthouse and hang out and watch trials like I'm a pretend attorney. I get excited when I have jury duty. It's another one of my really lame hobbies. So this is really it's like combining two loves for me. So I'm gonna do not so much maybe a dramatic reading, um, and I probably won't be able to control myself. So let's get started. I'm just gonna do the detention hearing. I haven't had as much time to go over the other transcript as much as I would like before I cover anything about it. Um, and again, thank you so much to Precious Kelp Pill and Precious Shin's Koala for making this happen for all of us. It's just another amazing gesture in a community of amazing trolls. You know, we all love making fun of Lorne, but we are so good to each other. I really love that about this community. Anyway, let's get started. Um, United States District Court, District of Maine, United States of America versus Lorne Lynn Armstrong, aka Lorne underscore A underscore 20014, defendant. For the rest of his life, that will follow him in any of these proceedings. I feel like every time he reads that or sees that, it's just another reminder of of the loser asshole thing he did. His alias. Transcript of proceedings pursuant to notice the above titled matter came on for detention hearing before the Honorable John C. Nivison in the United States District Court, Bangor, Maine, on the 22nd day of August 2019 at 10:11 a.m. Appearances for the government: Andrew McCormick, Esquire; for the defendant, Matthew D. Morgan, Esquire; for U.S. Probation, my new hero, Maria Schachman. And Ms. Julie G. Edgecombe, RMRCRR official court reporter. And I'm a fan of Ms. Edgecombe as well, hearing how kind she was to help us out like she did. I know that's her job, but it sounds like she really made this happen as quickly as she possibly could. If this is the lady everybody's talking about. Anyway, proceedings recorded by mechanical stenography, transcript produced by computer. Defendant present with counsel in open court. Thank you. Good morning, Mr. McCormick. Good morning, Mr. Morgan. Good morning, Your Honor. The court. We are here in the matter of the government versus Lorne Armstrong on the defendant's motion to reopen the detention hearing. We did have a detention hearing, a hearing on the issue of detention. Okay, yeah. And the court ordered that he was detained, to be detained, subject to his ability to seek the court's reconsideration of that through reopening the issue. And at the time, there was a question of whether Mr. Armstrong would be readmitted or part of sex offender therapy. That was at least one of the precipitating factors for the motion, and I know that there was an issue that was not addressed, at least to my satisfaction, at the last hearing. And so as part of the motion, there's been an assertion that he is eligible and has found a replacement program. So that's the basis of the motion. Mr. McCormick, from the government's standpoint, does the government contest the reopening? Or does the government simply contest whether he should be released? Where's the government on it? Mr. McCormick responds, it's the latter, Your Honor. The latter? So the government is not against reopening the hearing, okay, but does believe, Oscar, you can read Maria Schachmann's part, Oscar, if you like, but does believe that the defendant should be detained, yes. Okay, and for the record, the information provided with respect to a possible treatment program wasn't available at the time of the initial hearing. So I probably agree that the government's concession is consistent with the standard. So without objection, we'll grant the motion to reopen. I am by no means a legal expert, but sort of how I'm understanding that is these treatment programs or this plan that Lorne came up with his defender, I guess. These options weren't available at the time, and this is where he's going to plead. Pardon me. He's going to plead his case that, he found a private provider. And so then the issue becomes whether there are conditions that Mr. Armstrong could be released. It is the defendant's burden here at this point to establish by clear and convincing evidence. Mr. Morgan, are you ready to proceed? I am, Your Honor, yes. I'm going to do, I'm not going to do voices except for Lorne. Are you going to proceed by way of testimony or proffer? Or proffer, sorry. Proffer, Your Honor, the evidence. Okay, you may proceed. It sounded like he was already proceeding. The evidence submitted with the motion. The court made a determination when we were here last time, a couple of weeks ago, that Mr. Armstrong carried the burden in terms of the risk of flight. So basically, Lorne, I'm assuming because he's already been convicted, all the burden for everything is now on him. There's no, obviously there's no assumption of innocence. The government doesn't have the burden of proving that Lorne is not a risk. Lorne has the burden of proving he is not. I love that so much. There's been no change in circumstances. Is the court fine with me not readjusting flight? Unless the government believes the risk of flight, I didn't understand the risk of flight to be the government's concern in any event. So they're not worried about Lorne going anywhere. He's fucking broke. The only place he could go or would go is California to see his pretend friends, which would be fucking hilarious. And that's addressed later anyway. That's correct, Your Honor. Okay. That's not what it is. Okay, you may proceed. Okay, great. Then I'll just go right to the heart of the matter. This was emphasized the last time, so I don't want to belabor the point. Just be efficient. That's what we want too. Thank you, Mr. Morgan. But in terms of carrying his burden, the sort of primary piece of evidence that Lorne points to about risk to the community is the government's own petition. At this point, the revocation report's been made available too. There's no concrete assertion, even by the government, that he was a risk to minors in the sense that he was a risk from a sex offender treatment standpoint under his, basically the underlying conviction here, meaning he hasn't reached out to any young people on the internet. There's been no claim here that he has. There was no allegation that his drinking caused him to be a risk to the community. Namely, there was no allegation that, for example, he drives a truck, that he was drinking during work hours. No allegation that drinking caused him to reach out to minors on the internet. The issues, from what I understand it, are that he drank and lied, and that his lying and drinking caused him to be suspended from treatment. So there's certainly a hypothetical risk that if he's untreated as a sex offender, that he could be a risk to the community. Well, yeah, it's not a hypothetical risk. If he's even under treatment, I believe Lorne is a risk. So the conditions that Mr. Armstrong proposes to be released on would, in terms of the alcohol, first, would be that he continue AA. Probation's acknowledged that in June of 2017 he presented his probation officer, I believe it was the probation officer here, with his AA chip. Wow. So fucking what? Here's my chip. I went to an AA meeting. Let me let you in on a little something. Anybody could go in to just about any AA meeting and get a chip. It means nothing, and that's not to diminish or put down that program. You know, it's on the individual to take it seriously, to work on those issues. Showing up and getting a chip doesn't mean you're like cured of alcoholism. It means fucking nothing. He would continue with AA, which, from my understanding, Lorne went to some AA meetings and stopped at the liquor store on his way home and got beer. So who cares? It doesn't work if he's showing up to get a court slip signed, and that's it. He doesn't take any of the treatment seriously. He would be willing to be monitored by an alcohol device again. Well, how nice of him. Which is one of the recommendations sought in the final report. And he also would be willing to enter into substance abuse counseling at the same time as his sex offender treatment. And again, I'm not trying to demean substance abuse counseling or 12-step programs. I have a lot of experience with family members, things like that. They're great. But if the individual is not sincere, it means nothing. It means absolutely nothing. So that's to address any concern that his drinking would be a risk to the community, even though there's no evidence to show that it has been historically so far, and that is a lie. His drinking, there's clear evidence that his drinking has caused a risk to the community. I guess I get what he's saying here is that, and it's sort of like what Lorne was saying about his alcohol use had nothing to do with his original charge. So in that sense, the attorney is saying, you know, there's nothing saying his drinking would risk the community if he follows these conditions, AA or substance abuse program, along with his sex offender treatment. But his drinking is a risk to the community. There's evidence of that. The second piece is the sex offender treatment. I did speak with Mr. Hogan, who was the sex offender treatment provider, or the teacher at the rape class, I guess. He confirmed that Mr. Armstrong and Dwayne Hogan is a treatment provider who suspended Mr. Armstrong. He confirmed that suspended did not mean Lorne was not allowed to come back. He confirmed that suspended, in fact, meant that he would be allowed to come back, but not until after he had been punished. He told me the reason for that was that if Mr. Armstrong was allowed to lie and return to treatment without any punishment, that, in his words, would spread like wildfire among the other people being treated. It's a group therapy, and that's a fair reasoning. I can understand Mr. Hogan's position. I asked him if he had an opinion about whether Lorne obtaining counseling elsewhere outside of his facility would be sufficient to address his risks, and he told me he didn't have an opinion on that. That was his answer to me. And I don't know if the attorney is saying that to kind of make... Hi, hello, Oscar. How do you feel about that statement, Oscar? I don't know if that's sort of his way of making Mr. Hogan sound like he doesn't know what he's talking about. That's kind of how it comes off to me. But that's an honest answer. I don't think he would be able to answer whether that would address Lorne's risks. Who could honestly answer that? We did find Lorne reached out to treatment providers. He found one here in the Bangor area. That's Exhibit A to his motion to reopen the hearing. They have immediate openings. They provide both individual and group sex offender treatment. I disclosed to them the basis of why he was seeking treatment with them, namely, that he had lied to his previous provider. They did not say that would keep them from treating him. He didn't say, notice, the attorney didn't say, the provider said, that's cool, we'll take him. They just didn't say they wouldn't. That wouldn't keep them from treating him. It's kind of an interesting. So at this point, he has sex offender treatment services that he's willing and able to pay for. Or let's say his family is going to be paying for. He's willing to be monitored from an alcohol standpoint. And there hasn't been any allegation that either of those two things, either the lack of treatment, I'll put that aside, that his drinking caused a direct risk to the community. And he's addressed the issue about the sex offender treatment counseling by finding new counseling. I don't think that really addresses the issue about the sex offender treatment counseling. I think the core issue is that Lorne lied in his treatment, and the consequence of that was being suspended from his rape class. So Lorne just goes and finds another provider. That doesn't answer the core problem of him lying in his treatment. What's to stop him from lying and he will, but what's to stop him from lying with this other provider? It doesn't answer anything, in my opinion. Then again, I didn't go to law school. I'm not an expert. That's just the way I see it. So based on that, he's carried his burden to show by clear and convincing evidence that he should be released. This isn't a question about whether he should be punished, simply a question about whether he should be released pending his final hearing. Thank you, Mr. McCormick. Yes, Your Honor. First, just in terms of the drinking, the government takes issue with the fact that he's drinking doesn't lead to an increased risk. The government believes that it does. Of course it does. Of course it does. And in my conversations with probation, is that when you drink, your inhibitions are less. And based on his prior conviction, I think it does increase the risk. He's 100% right. Lorne drinks specifically to forget his past. And when you do that, you continue to make the same poor decisions. And it does cause you, to not think clearly. And Lorne already has a problem with that. Now, there is no evidence that I've seen at this point that he has reached out to minors. But I think drinking in combination with his prior history is a risk. And I would agree with that. And in addition, Your Honor, I do think that it's significant that these are not one-off drinking things that he has been involved with. I mean, one of the statements from the petition say that on July 24th, 2019, Armstrong admitted to probation he had consumed alcohol on July 7th, 2019, and reported he had been consuming alcohol on a weekly basis since the completion of SoberLink testing on December 4th of 2017. And he consumes on average 7 to 12 beers in a sitting. That's probably a low average. And I also find it interesting, in light of the most recent call that I was talking about, that we were all listening to together, when Lorne was trying to convince Ramona that device had nothing to do with him wanting to stop drinking. But isn't it interesting that it's, as soon as that device was removed, he's right back at it. So I think the risk, Your Honor, is not only that he seems to have a very serious issue with alcohol, but also that he seems to just frankly be ignoring the rules, which I think is a concern. That he finishes his SoberLink training, like he's being trained like an animal to not drink. This is SoberLink training. Gets hit on the nose, punched in the face when he drinks. He thinks he can continue to go on drinking without any repercussions. And I think the fact that he is willing to ignore those rules, in combination with the fact that we do have evidence as well, too, or at least there's an allegation about his involvement in getting a smartphone, which again is ignoring the rules that are clearly laid out for him. I think those are all risks to the community, and I think that's simply, basically what I feel like is happening in this case is that he gets kicked out of a sex offender program and he goes and finds another one, and I'm not sure that really addresses the risks involved. That's exactly, that puts it much better than what I was trying to say, but that's exactly what I feel like. He gets kicked out of a sex offender program, he just goes and finds another one. He puts a band-aid on the problem, and he continues to do what he's always been doing. So I think that detention is appropriate, Your Honor. Do you know what the guideline range is if there is a violation here? 3 to 9 months is my understanding. 3 to 9? Yes, Your Honor. Thank you. Probation, want to weigh in on this or add anything? Officer Shockman? Hell yeah, she does. So Ms. Shockman, this is the beauty part. Your Honor, I would just add that like it was already stated that the alcohol is an issue with lowering inhibitions. And there was an issue with Mr. Armstrong throughout supervision and having conversations over the phone with females that he had never met. And we could not determine what their ages were. So that continued interaction with people online that he is unaware of who they are goes back to his original offense, and that is a risk. 100% right. Tell me, and in light of that statement, again, I think back to Lorne using probation, their concerns to force these women to come and meet him. And he makes it sound like, probation is looking into them, into these women. It's almost like there's an underlying threat of, probation's on to you if you're lying to me. But it's really, and he can't see this, probation is not there. I mean, I guess they're there to help him, but he almost treats, his probation officers like they're his, his bodyguards or his, they're looking out for him. They're looking out for the community. They're not looking out for Lorne. He just will never understand that. Tell me the relationship between his conduct that you were monitoring and the original offense. The original offense had to do with having a conversation with a person he believed to be an underage female online. That he continued to have this conversation, and then he went to meet with this person, but it was actually an undercover agent. And that, in the eyes of probation, correlates with the same behavior now of having conversations with females on the phone. We don't know their ages. We can't confirm if they are adults or not. And that's true. Lorne uses quote-unquote evidence, like about Ramona, like, oh, well, she has a job. She has, underage minors don't work an 8-hour-a-day job. Well, did it ever occur to you, Lorne, that she could be lying about her job, or basically, like she was lying about everything else? And what was probation or some law enforcement able to monitor the substance of those communications? We were not able, to a limited degree. We were checking text messages, and we would receive anonymous emails and phone calls about his behavior with links to recorded conversations he had with females over the phone. So they would check his phone, I guess the one he didn't lock in his filing cabinet. And someone sent emails and made phone calls to his probation officer. That doesn't surprise me. One of those conversations that is included in the revocation report, he had asked one of the females to provide sexual images of herself and to send them through the mail so that probation would not be able to find them. It's all falling apart for you, isn't it, Lorne? Hello, Oscar. I can't read when you're in front of me. How long ago was that? May I check my record? Sure. That was in February of 2018. And has there been any of these communications or any communications that have been checked to your knowledge? Have they involved in any way someone who was a minor? So there was a conversation that Mr. Armstrong, he had called me on the phone. This is not highlighted in the report, but approximately, when was this? This is so good. This was approximately 5 or 6 months ago. Okay. That he had called me and asked a request to move or go out to California to meet with this individual he had been speaking with over the phone, that he had never met. We had no proof of who she was, and he was informed by associates of hers that she was in the ICU and she was very sick. He had requested to go out to California and to marry her as her last request because he was informed that she may pass away. Yeah, Lorne would really believe that a woman's dying request would be to marry him. And he had sent me an image of a female that he believed to be this individual in the hospital, or the hospital, as Lorne says. Upon doing an exam on that image by my office, we found that was actually an image of a 15-year-old girl who was in a coma based out of a London newspaper. The photo was out of a newspaper? Yes, that somebody had sent to him to make him believe that it was that individual, and that is concerning to U.S. probation because that proves my point that we don't know who these people are or what their ages are, and he was under the impression that this was an adult female when, in reality, this was an image of a 15-year-old girl in a coma. She's 100% right. Lorne shows over and over and over again his irresponsibility. He can't be trusted to make his own decisions about things. And all it would take, truly, it would take, a 16 or 17-year-old to reach out to him and convince him that, she's 18. Because he'll fall for fucking anything. Had he received that image? He explained to me that this individual's associates had sent him that image over the phone. Is it apparent? Is the person's relative age apparent from reviewing the photo? No, Your Honor. She looked young, but I could not tell that she was of age or not. And how was that resolved? Was he granted permission to go? Was he confronted with what the reality was? How did that resolve? And it didn't resolve because Lorne continued. Yes, his request was denied, and I explained to him what we had found, that this was not the person he thought it was, and he was very upset that they had lied to him. But then months later, he continued to engage with those same individuals who had been lying to him. Unfucking believable to me. It's truly... He finds out this isn't Winnie in a coma. It's a 15-year-old girl from a newspaper. He looks like an asshole in front of his probation officer. He has evidence now, against him to his detriment. My first thought would be to cut off all communication with these people. But they told him some kind of ridiculous, crazy story, I'm sure. And he's right back in the thick of it. His group of friends. It blows my fucking mind. You mean the associates of this person? Yes. Or the purported associates of this person? Yes. Okay, and how long did that go on? To my knowledge, that has continued to go on throughout his supervision. Continue to communicate with those individuals? Over the phone. And where are they located, do we know? We do not. Are they women? Yes. And the government has mentioned, and you have mentioned, alcohol consumption as being an issue. Is there any evidence of alcohol use during, this incident with the communications with the person who turned out to be 16 years old, or her associates anyway, or any of the other communications about which probation is concerned? So, one of the links that U.S. probation was sent, there was an audio clip of Mr. Armstrong having a conversation with a female over the phone. I would love to know which one that is. I would love to know. He appeared, or he sounded as if he was intoxicated. He was slurring his words. So we confronted him about that audio clip, and he had admitted to my supervisor that he had been drinking during that conversation, and that was, in fact, him on the phone. I note on the docket that there was relatively recent, within the last month and a half or so, a request that was not objected to by Mr. Armstrong for a modification of his conditions, which imposed, I guess, the what I would consider the computer monitoring condition or internet monitoring. Is that right? That was updated language recently. Right. We had. It was already there. Yes. And what was the reason? Was there any particular reason why it was modified in July? Or was that just modified language that became standard from probation's perspective, so they sought to modify it in every case in which the computer monitoring condition had been imposed? That's correct. So I guess in this case, the modification that he signed was a change in the language to the condition, and every individual who was under that condition had to sign this thing, showing that they had been advised of the change. However, we do know that Lorne signed many other modifications in lieu of requesting a hearing and possible punishment, because he thought, again, I'll put a band-aid on the problem. I will continue to do what I want to fucking do. Okay, all right. So what is probation's view on the proposed release plan? I actually am going to have to wrap this up. I have an appointment. I just realized that I'm going to be late for her. I will continue with part 2 of this. I was just so excited to do this. I just let time get away from me. Anyway, I will be back with the second part of this. We're going to leave off after the court says, so what is probation's view on the proposed release plan? I will talk to you again soon. Bye, sweethearts.